counsel pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm enclosing the nominee's resume for your convenience. To start the hearing, we will have the witnesses who are here to testify in favor of you, and they may come and stand or sit next to you. The first one is the Honorable Daniel Wren, Associate Justice of the Superior Court.
Good morning, councilors.
Good morning, Judge.
It's my pleasure to be back here before you. I think I last saw you in support of Courtney Price, who I'm to say has been a home run, right? It's always an honor to appear before you. I think this is my 6th time before you, including my own confirmation hearing. It's always good to come back. I've had the privilege of knowing Brent since the early 90s, early to mid 90s. Brent and I both grew up in the Worcester County practice of law. We met each other in the local courtrooms in the district court. We were young lawyers back then. And sad to say, I don't know that we still are young lawyers, but he is, right. So Brent and I had the good fortune to represent similar clients: Pro Mutual, UMass Memorial, Bay State Medical, other med-mal, insurers and self-insurers. And we had co-defendants together. So I want to say we had 100 cases together. I grew to respect Brent greatly as a lawyer. You know, the best thing I can say about Brent is whenever I had a case with him, I knew he'd be on time, prepared, and trustworthy. And if you've got those 3 attributes, you're in good shape. But we then became very close friends. I got to learn about his mom and his close relationship with his mom. I got to learn about his family. He got to learn about mine. And one of the bad parts, the only real bad part other than judicial response of being a Superior Court judge, is you can't maintain your friendships with your lawyer friends because they're going to appear before you. So when I took the bench in 2011, I didn't see Brent anymore. So that was a negative. But during the years that I did know him, practice with him, and get to know him, I have nothing but positives. I really enjoyed the relationship, and I number him among the best friends that I had as a lawyer, both personally and professionally. I also have the unique perspective that he's appeared before me. I did a medical malpractice case with him and Rob Higgins, and you know, it's like driving a Cadillac. They come before you, you don't have to do much because you know the level of preparation, the level of professionalism. I just had to get my charge ready and wait till they were done. I cannot recommend Brent strongly enough. I've been on the bench for 11 years. I think I have a sense of what attributes it takes to be a successful Superior Court judge, and I think Brent did every wants. And frankly, I can't tell you how excited I am to have him back as a colleague and friend, because I look forward to that. You know, one of the things that you folks probably think about is great civil lawyer, but what about the criminal side of it now? What I can tell you about that is Brent did medical malpractice work. And in medical malpractice work, one of the primary skill sets you have to have is you got to learn medicine. So all of us got into law because we couldn't do math and science. So the first thing you do when you get a case assignment is you go to resources, you teach yourself the medicine, you learn the language, because that first meeting with the client is imperative. They got to have confidence in you. So when you walk into that first meeting, you got to know the language, you got to know the medical procedure, and you got to know your way around the anatomy that's involved in that case. And I can assure you that that independent learning function and the ability on a short leash to learn that medicine is going to serve him well when he takes on the criminal docket. I had the same learning curve, and I think I was able to get through it pretty quickly and efficiently, and I'm confident Brent will do the same thing. Again, 100% recommend without reservation. If there's any questions, I'd be more than happy to move on.
Yes, sir.
It's good to see you again, Judge. You know, I brought up the issue with him when I talked to him the other day about the fact that he beat up my friend Rob Higgins in that trial. And he's a great lawyer, I know him well. you know, I agree with you. The permit issue is always an issue when we have people coming in from the civil bar, whether it's on the defense side or the plaintiff side. But, you know, people can transition. I don't think you had done much criminal, in my recollection. It was all defense, basically, right? And you've done a great job with it. So, and you're doing a great job as a judge. You have a great reputation. I don't get out there much, so I don't get to make fun of you while you're on the bench. So I have to do it when you're here.
Don't worry, others are well ahead of you.
It's good. But you're doing a great job. Thank you for coming. Your words mean a lot.
Thank you very much.
Any other councils?
Thank you, Judge.
Step away. Thank you so much. John, I've just changed your gender. Joan Worcester, partner from Merrick O'Connell in Worcester.
Good morning, councilors. It is a real honor to be here today to speak on behalf of my friend and colleague, Brent Tingle. Brent and I have known each other from the early mid-1990s. We were both junior associates. Brent was at the Worcester branch of Morrison Mahoney, and I was at Myrick O'Connell. And I'd like to say that we grew up together as lawyers, covering depositions, taking depositions, learning how to argue in court, and eventually that morphed into trying cases together. What I'd like to share with you today is an experience that I had with Brent trying a very emotionally charged, difficult medical malpractice case, because like Brent and Judge Wren before he was on the bench, I too am a medical malpractice defense attorney. And I want to tell you a little bit about this case, because I can tell you, we did it by arbitration. That decision was made to do the case by arbitration as opposed to go to a jury trial, because it was a very challenging set of circumstances. And it was Brent and I defending the case together. And the last day of the arbitration had been held at my office in Worcester. And the last witness took the stand. He was an expert witness, and he was devastating to the plaintiff's case. Now, I'll point out to you, I'll give you a little background about the case. It was a gentleman who had sought medical attention at one of the Boston hospitals, and he suddenly died in the emergency room of that Boston hospital right in front of his wife. And so needless to say, going through this arbitration was very difficult for her. She was overcome. She did not attend the last day, but the gentleman's 2 adult children did. And at the end of the testimony, the last expert witness had taken the stand. There was a lot of testimony about the circumstances of how this gentleman had died, a lot of opinions that, quite frankly, were very critical of the plaintiff's case. We got done, and I set about to pack up my things, because in any medical malpractice cases, there are large files, there are volumes of documents we have to deal with. And as I was packing up, I looked up, and Brent, who had been sitting next to me just as he is today, had gotten up and walked behind me and around the arbitrator, and he was going up to the 2 adult children, the 2 young adults who had sat there listening to this testimony regarding the death of their father. And I looked up and I saw Brent reach out his hand to each of those 2 young adults, tell them how sorry he was, and recognize how difficult it must have been for them to sit through that testimony and listen to all of these facts regarding the death of their father. And I can tell you from looking at their faces that they were so grateful that Brent had gone up to them with genuine concern to recognize their loss and to recognize how hard it was for them. And I share this with you because I think it's a great example of Brent's innate qualities of compassion and empathy and just sheer kindness that he will bring to the bench. And you know, that kind of a reaction, to have your first thought at the end of a hearing, to get up, to go and comfort your opponent, that's not an afterthought. That comes from within. That is deep within your soul. And I think that for this council, you need to know that, because that's what you're going to get if Brent is confirmed as a Superior Court judge. He will bring that empathy with him and that understanding to the bench. Now, not to say, I have no doubt that Brent will know how to run a courtroom. He will know how to handle juries. He'll know how to talk to juries. He'll know how to handle witnesses. He'll know nonsense when he sees it, and he'll know when to tell litigants and lawyers when to knock it off. But those innate qualities, that compassion, that empathy, that kindness, is what is going to set him apart. Because I think for every litigant who comes into a courtroom, I think those litigants want to feel respected and they want to be heard. And I have no doubt that Brent brings those qualities, will bring those qualities to the Superior Court bench if he's confirmed. On a personal note, when I heard of Brent's nomination, I was personally thrilled for him. I was sad for myself. Brent and I have a lot of cases together. I will miss him as a co-counsel. We're scheduled to try a case together in February. I expect he won't be there with any luck, and I will miss him. I will miss his steadiness. I'll miss his wise counsel. I'll miss the guy that I can pick up and call at 7 o'clock in the morning and say, hey, what do you think about this? Because we always have interacted that way. And so I say it again, I will miss him as a colleague and a co-counsel. However, more than anything, I am absolutely thrilled for the residents of this Commonwealth, because if he is confirmed, you will be getting yourself a really awesome Superior Court judge. So with that, if anybody has any questions, I'd be happy to answer them.
I have to say that was very compelling testimony. Thank you very much. Councilors, any questions?
It was, thank you.
My pleasure. Thank you.
Councilor Ianella has joined us.
Nice to see you also. Oh, thank you very much. Thank you.
Are there any more witnesses in favor? Are there any witnesses opposed? Hearing none, you may make your statement. Before you do, if there's anyone you'd like to introduce to us, feel free to.
Sure. Thank you very much, Councilor Duff. I'm joined here today by people moved around, so I'm joined here today by my wife, Joanne, around the room. I was looking for her, and my dear friend, Joan Worcester, and Judge Wren, who you spoke or heard from just a moment ago. And then my brother Brooks is sitting behind me here as well. And then our oldest and dearest friends from our hometown of Westford, Lila Alphonse and her husband, Mike Saunders. And I was joking with Judge Wren this morning when I introduced them that if, God forbid, anything ever happens to Joanne and I, Lila and Mike get to raise our kids. Because our kids have known their kids since they were little, and they have a very special role in our children's lives, and vice versa. So thank you very much. I'd also like to start out by thanking both Governor Baker and Lieutenant Governor Polito for the confidence that they've shown in me in nominating me for this position. Also to thank each of the councilors that are here today and those that are joining us remotely as well. I really enjoyed getting the chance to speak with most of you before the hearing today. I know things have also been extremely busy for the council, so I'm really grateful for those who were able to speak to me, and I'm completely understanding of anyone who I wasn't able to connect with beforehand. But that was really meaningful to be able to get to know you a little bit beforehand. I also want to thank and acknowledge the Governor's Chief Legal Counsel, Bob Ross, was just great every step of the way, asked great questions, and just brought a lot of enthusiasm to the process too. And Lauren Green Patrigno, the Executive Director of the Governor's Council, who of the Judicial Nominating Committee. I don't think I would have survived to this point in the process, but for her, she was just a wonderful support, incredibly knowledgeable about the process, but also just someone that in those long periods of time where you're sort of wondering what, if anything, is going to happen to you, she was just wonderful to deal with in that regard. And also her colleagues, Emily Gauthier and Valerie McCarthy from her office, just great to deal with as well. So my thought was, I'm going to be brief, but my thought is to hopefully tell you a little bit about who I am as a person, a little bit about my legal career, although I hope that what you've heard and what you've seen in the application and the questionnaire that I submitted to you will give you pretty good background in that regard. And then also share a little bit with you about what I've tried to do in order to prepare myself for this hearing today, and also prepare myself in the event that this council favorably on my nomination today as well. So in terms of how we got here, my brother Brooks and I, we grew up in the seacoast, New Hampshire. Our parents, mother and father, both grew up in a very rural area of southern Delaware, very poor area. Neither of my parents graduated from college. My father went for 2 years and then joined the Navy and became a Navy pilot and a commercial airline pilot after that. My mom hadn't worked outside of the home until my parents split up and divorced. when we were in junior high, which was a really hard time for my brother and I in a very challenging situation. And I think more than anyone else, the person I would like to acknowledge today would be my mom, who really raised my brother and I, and did it after having to go and join the workforce for the first time in her life, and who went on to have a really successful career as an executive assistant to senior executive at one of the pharmaceutical companies, and was an incredibly well-respected person within that company as well. And my mom passed away on Christmas Day 2006 prematurely from cancer, but it's really meaningful to be here today in this position, because I can't tell you the number of conversations I had with my mom over the years about, she would always say to me, is now the right time to apply to be the judge? Because I'd started out as a law clerk in the Superior Court, and I told her that, oh, this is probably the best job I'm ever going to have as a lawyer. And I said, unless they ever let me be a judge someday. And so she would always ask me, is it time yet? Is it time yet? And I'd always tell her, it's not time yet. And I'm saddened that she wasn't able to see this, but I'm glad that I told her it wasn't time yet, in the sense that if I reflect back on where I was professionally and the life experiences that I had up until my early to mid 30s or even early 40s, it wasn't time yet, in the sense that some of the experiences that I had, including my brother and I going through my mom's illness and her loss. Joanne and I have a 17-year-old daughter, and a 15-year-old son. Our first child, Hunter, was stillborn at full term when my wife was a couple days past her due date. And that experience, followed by an experience with my mom, it deepened my appreciation of the human condition, deepened my appreciation and capacity for empathy and compassion, I hope. And out of that tragedy, at least, I hope that I move forward as someone who is better able, perhaps, to serve in this position if I'm approved, by virtue of the fact that those are defining experiences that you have in your life. When I think about how I got here to be a lawyer, it's sort of an interesting story, in the sense that I managed to go to law school literally not knowing a single lawyer. There were no lawyers in my family. I don't think there's anyone I could say that I actually knew that was a lawyer, but I'd always had it in my head that I thought I wanted to be a lawyer, because I like to talk, and I like the idea of being able to help people, and I like the idea of being a teacher that came with doing trial work as well. So after I graduated from UNH, and if I am very proud of my brother also, is a year and a month older than me. He and I both went to UNH. His first job leaving UNH was as low of an entry-level job as you could possibly have at John Hancock Insurance Company. I think he made $12,000 a year in his first job. He stayed there his entire career. He's the CEO of John Hancock Insurance Company now. And my mom is extremely proud of him for that as well. But just briefly, in terms of how I got here, I went to law school at Northeastern for two reasons. I wanted to make sure I wanted to be a lawyer, and I was terrified that if I went to 3 years of law school in a classroom, that I still wouldn't know whether I wanted to be a lawyer or not, and I would have borrowed a lot of money in order to get there, because I borrowed all the money for law school. And the other reason was I wanted to go to Northeastern because of the co-op program there, because I thought that I should probably meet someone who's a lawyer along the way who might be able to help. And that ended up being just an incredible experience for me, because the first person that I worked for in my first co-op job at Northeastern was a lawyer named Joe Regan from Lowell. He worked at Donahue and Donahue in Lowell. Joe was a brilliant trial lawyer, and for whatever reason liked me and liked the work that I did. And I can draw a direct line, I can connect the dots from the first co-op job and the first positive evaluation. I still remember the evaluation that he wrote for me, because he said I knew how to separate the wheat from the chaff, and I wasn't sure what that meant at the time. And that job led to the next co-op job, led to the next co-op job, led to me applying to be a law clerk in the Superior Court. They had already filled all the positions, but a couple people had changed their minds, so I was literally applying for the position that no one else wanted at that point. And the person who interviewed me was the chief law clerk, said, "You worked for Joe Regan?" I said, "Yes." And I said, he's one of my references. And she said, "Well, I saw him argue this thing in court recently. He's one of the two best lawyers that I've ever seen. And if he says you're okay, then you must be okay." And then the same thing when I came to Morrison Mahoney, my first job there and my first mentor there, Joe Suckler, had cases with Joe and said, "If Joe vouches for you, I'll hire you for this job." And that was a really important life lesson for me too, about the importance of connections that you form with people. And you have to earn it. You have to earn people's confidence and respect, but that none of us would ever get to where we've ended up if we didn't have people who believed in us and were willing to mentor to us. And that's something that's been incredibly meaningful for me as a lawyer over the course of my career, is serving as a mentor and teacher to other younger lawyers. I think it's one of the best and most noble traditions in the profession, that each generation teaches the next generation of lawyers how to do it. And that's been really meaningful for me as well. In terms of the work I've done, you've heard both from Joan and from Judge Wren about that. I started out with a pretty broad base of civil experience. I did a little bit of everything initially on the sort of civil trial side, but eventually found my way into doing this medical malpractice work. It's been a great career for me, incredibly rewarding. I had the most interesting people in the world from my clients, from Children's Hospital or Mass General and the like. And additionally, consistent with the story that Joan was very kind enough to share earlier, I really, really enjoyed being able to have.
Do you want a mask? Okay, go ahead.
I'd be glad to put a mask on as well if you prefer.
No, I know. Councilor has an.
Interrupt,
No,
Councilor.
Councilor.
I just I got sick coming in, and the Rangers don't want me to be, I don't know, this is so embarrassing, and I've never missed this assembly, but I do want to say, Madam Chair, that I met with this nominee, and just outstanding. And I know it's an issue with you, and as I asked the last nominee from the Superior Court, I asked you if the only matter of abortion that comes before you is the only matter of abortion that comes before you is if a 13 or 14-year-old came before you asking for seeking an abortion without parental consent. And you told me that you said he was pro-choice. My last one said, the last person said that you would recuse yourself. So
Mr. Devaney, he's in the middle of his opening statement. We're not at.
I know, but I have to leave, so I'm asking your permission to speak now. Thank you. So I just wanted to say that I really regret leaving now, but I just wanted to say, Madam Chair, that both the last Superior Court, one said that she recused herself, and I believe that she's truthful, and I believe you said you're pro-choice. I regret this, and I don't want to stay just in case. And I apologize to everybody, and I didn't want to interrupt.
Thank you very much for being here. Thank you very much.
Express those sentiments to the next person. You don't have to come back up. The next nominee.
I'm sorry. Go.
No problem. I apologize. I've gone on for too long. I'll wind things down now. I just wanted to share that it was remarkable having the clients that I did in terms of the healthcare providers that I represented over the years, and just some of the most amazing people. But equally important to me was how I interacted with family members who had gone through a terrible tragedy, and oftentimes were just looking for answers or wanted a way of grieving through this process. And particularly because of some of my own life experiences, that was really, really important to me. And my goal more than anything else was to work as hard as I could for my client ethically, but also to show the greatest respect that I could for family members who had experienced a tremendous personal tragedy. Lastly, I just wanted to touch briefly on the fact that what's been pointed out before. I've been really a civil lawyer most of my career. I've had some overlap because I've had a number of cases where there was a companion criminal case that I've tried, and I've taken a lot of depositions in the state prison system and the like. But I acknowledge that I have a lot of learning to do in that regard, and I wanted to just share really briefly what I've tried to do in terms of getting the ball rolling on that. I've spent most of the last week and a half watching a murder trial that was going on in Middlesex County, which ironically, I was watching Judge Dunnigan's hearing the other night, and she was speaking a lot about these two cases she had prosecuted for a murder in Everett, with these young men from the MS-13 gang who had been involved in this killing of another young man, and there were no winners in the case. It was tragic all the way around. Coincidentally, this happened to be the third of the three defendants in that case that was going to trial, so I've spent some time watching that. I've done some MCLE work on important criminal law cases, and I've also read in its entirety the Superior Court study that Justice Gantz commissioned regarding racial disparity in the Massachusetts Superior Court. It's an important issue to me, and I was really relish the opportunity to read that study and to get more information about it. And finally, I have sort of mentors lined up in terms of people who will be on the bench, including Judge Wren and my friend Pat Hagan and others who are have more criminal experience that will be there to be mentors to me as well. So I apologize. I tried to be short-winded and I ended up being long-winded, but I'll stop there and would be glad to answer any questions that the councilors might have.
I'm going to start with the councilors who are here with us remotely. Councilor Hurley, can you hear me? Councilor Hurley?
Yes, I can. Yes, I can.
Any questions for the nominee?
We had a great conversation the other day. I always am cautious when it comes to civil practitioners getting on the bench with no criminal experience, but after talking to him and listening to him in terms of the homework that he's done already and the seriousness with which he takes his responsibility to get things right and to really do the job the way it should be done. I talked to him about that murder case. We talked about sentencing. We talked about a lot of different things. And I am satisfied that he's going to do a great job. So thank you very much, and I wish you the best of luck. Thank you.
Thank you, Councilor Hurley. Councilor Fiera is also remote.
Thank you very much. I had the opportunity to speak with the nominee a couple of times. And today I just realized that, you know, you can always tell the guys who get paid by the hour, they speak the longest. but you did a great job. We had great conversation. You have the admiration of Jay Lynch, who I've been working with for 30 years. You have the admiration of Gareth Notice, who I know from your firm. I've dealt with extensively. And I think you're going to be a great judge, and you certainly have my support next week. Thank you for applying.
Thank you, Councilor.
Thank you. Thank you, Councilor. Councilor DiPaolo?
Sure, thank you. Is that okay? Good morning.
Excuse me.
Oh, I'm sorry.
I'm used to being left out, don't worry.
Oh,
I just assumed you wanted to skip Councilor Kennedy.
I don't have much to say anyway.
all right, Councilor Kennedy, I'll stand
We've
corrected.
been talking for a long time about potential judge, probably at least a year, if not longer. And we've had many, many conversations over the last for extended period of time. And I had a very long conversation with you the other day about all the things that you've done in preparation for criminal work. It's admirable. Not everybody shows up there doing that kind of homework. They sit there and say, well, I'm going to learn when I get there. You're already ahead of the game on that. You're doing a great job with it. I can tell you right now that we have, which we typically get people coming in doing criminal cases primarily, they're not getting ahead of the game for the civil side of things. They don't tend to do that. So, yeah, you're a home run. There's nothing to talk about. You're going to be a great judge. You have the temperament, you have the experience, and I'm going to be voting for you next week. Thank you.
Thank you very much.
You are welcome. Now I'm totally confused because I was just going in there.
Well, it's confusing because he moved. He didn't want to get sentenced.
Well, go ahead, Councilor DiPaolo.
Good morning.
Good morning, Councilor DiPaolo. Nice to speak to you.
We had the chance to have a good conversation. So I want to hit on a couple of the points we discussed and maybe a couple of others. So first off, likewise, I know how complex your the litigation practice area you're in is. It's extremely valuable for the Superior Court to have that civil experience. But regarding the lack of criminal experience, one thing we talked about was my concern that someone without the criminal experience comes in and is deferent to the state, to the Commonwealth, whether it be around sentencing decisions or anything else. And I'm wondering how you will approach crafting your dispositions and sentences independently, without deference to the state.
Sure. I guess I would say first that sort of part of my bedrock view on our judiciary is that it has to be grounded in a strong, independent judiciary where people make decisions without regard to the public or the Commonwealth or the defense bar, whatever the case may be. So I'm very much grounded in that. The other thing I can say on it, and I think I may have shared this with you the other day, Councilor DiPaolo, is that I really come to the criminal work, agenda's the wrong word, but I come here without a view sort of favoring Commonwealth versus the defense side. I'm really a blank, I don't want to say blank slate, but I really come to it without a perspective one way or another on that. In other words, I don't come showing deference to one side or the other on that. Yep, I'm sorry.
So let's pause right there. So you come at it from this neutral, dispassionate perspective. So let me ask you this then. When is public safety served by incarceration, and when is public safety not being served by incarceration?
So I think it comes down to the nature of the offense, the circumstances of the offense, and I don't mean to get granular about it, but there's so much of that that is case specific. I can tell you philosophically, I believe that there are many, many instances where public safety is not served by incarceration, and I'm a big believer.
Why do you feel that?
Because for two reasons. Number one, for nonviolent offenders, and even in some cases with a violent offense, there may be other ways to address that short of incarceration in a particular circumstance. Is one answer. The other reason is sort of the unfortunate pipeline that we have now from people who start out end up with a juvenile record or interactions with the criminal justice system at a very young age. By the time they reach a superior court offense or end up getting perhaps charged with, or in some cases overcharged with, an offense that brings them to superior court, they sort of bring that baggage with them. And then you end up sort of mainstreaming them to the point where further incarceration of an individual, if there was any possibility of avoiding further criminal activity from them, I think that's often foreclosed once that person is incarcerated.
That's something a lot of people call the school to prison pipeline.
And I prefer it more succinctly than
school to prison pipeline.
right. Exactly.
And so when you're thinking about that, and I'm glad you're mindful of all that, you're the judge, a young adult is in court as a defendant. You don't know what their background is. And someone who's endured childhood trauma isn't likely to be willing to be super forthcoming to a room of strangers, especially a courtroom, or even to their court-appointed lawyer, if that's who's representing them. So if those kind of childhood traumas that exacerbate or delay brain development, et cetera, how are you going to know that they're there? Because sometimes the lawyers don't know that.
It's an excellent question, and I'm not sure that there's a real easy answer for it. I will start by saying that by virtue of the nature of the work that I do now, I spend a lot of time reading medical journals and a lot of time reading things about the developing brain and in the field of neurology. And I'm a believer in an acknowledger of this notion of the developing brain. Frankly, as being a parent of teenage kids, it's hard to believe that there's anything to contradict it at that point. So I'm certainly conscious of that. That would enter into the thought process at any point in sentencing of a young adult in that regard. Beyond that, though, you flag the challenge, which is the conduit for being able to figure out what to do in that situation is information, and how do you get the information. So part of it comes from whatever information you can get in terms of sentencing memoranda from both sides in the case, information about the background of the defendant that might come from family members or other people as part of that sentencing memoranda, what information probation might be able to provide or a pre-sentencing report might be able to provide in that regard. But I think a lot of that is trying to get information on a granular level in the individual case. Because
just being asked sometimes helps, right? Just simply being.
It starts with asking the question.
On something we discussed and something you're hitting on. So we craft sentencing different for juveniles, right, than for adults. And there's a lot of reasons for that. One of them is brain development, right? And how it impacts culpability and decision-making and all that. So now we know, as you're articulating, that brain science has unambiguously demonstrated, I mean, we can hook up probes to someone's head and see the activity, and we know for sure that development's not done. So if development's not done yet, it seems to me that there's a huge opening in the jurisprudence that the SJC created with Dyachenko and comments since then to really pretty radically rethink how we sentence young adults. Would you agree with that?
I do agree with the proposition, and it's why I'm such a believer in an independent judiciary in terms of sentencing, and I recognize the the conflict between those scenarios that you've just describing and scenarios where sentences are prescribed by statute, where you don't have discretion.
And we discussed, and shame on me because I don't have the case name in front of me, but there's a recent lower court case that discussed sentencing for juveniles. That's going to probably work its way up. So at Superior Court, you have the power to do that. And as my colleague, Councilor Jubenville, always says, they can't fire you. So if you're bringing that expertise around the medical side and the brain development side, to me, that's something you bring to the Superior Court that you can make a real huge difference on. Because I know the legislature has talked about raising the age for juvenile jurisdiction. We see they don't always get to all the items on their checklist. So do I have a couple minutes left, Councilor?
Yes, you do.
Last thing then, you brought up the Gantt study. So Superior Court is where sentencing disparities happen according to the Gantt studies. It's mostly around drugs and weapon charges. And so why is that happening? Because we control for all the factors. I understand if you have a trunkload of weapons, and I can see why you'd end up incarcerated, I suppose. But why is it happening?
Well, the Gantt study essentially tried to control for a number of those different factors that might account for those racial disparities between Black and Latino defendants and length of sentences. And even when adjusting for those factors, they were still finding that the Black and Latino defendants were still serving on the order of, I think it was 30 days or something like that long.
The average is 28.
Yeah, the average is 28.
28 for Black and 32 for Latino. And then it's like, if you just look at those drug and weapons charges, it's like 130 something days.
Yeah.
Which is a long time.
Right.
A long time to be in jail. Because we're spending 90 grand a year to keep them in jail. And we have the highest Latino incarceration rate in the country as well.
Right.
And as you know from reading the study, when you're charged with something with concurrent jurisdiction between district and superior, you're twice as likely to be in superior if you're Black or Latino.
Right. You're more likely to end up in superior, and you're more likely.
Therefore exposed to the larger sentence. Does that inform your work as a Superior Court judge, do you think? I mean, so someone, the circumstances of someone getting there is, there's all these factors that really aren't pertaining to their behavior as much as their context.
And I can tell you, Councilor, that probably the best way for me to answer that is to say that I'm a data-driven person. I want more information than less information, and I like to get information like that and process it in an individual case. And I acknowledge those issues that you're flagging, and I think some of those solutions, as you pointed out, are legislative in terms of raising or sort of expanding the jurisdiction of the juvenile courts. But I can tell you that in terms of sentencing decisions, I'm very much aware of the data that came from that study, and I also acknowledge that it's a starting point, not an end point, in terms of how we go about tackling those issues.
Last question. What would be your standard to hold someone in contempt in your courtroom?
I have a hard time imagining circumstances where it would happen, because I started out trying cases in the district court where, boy, I had some days where I was frustrated, and I said, I wonder what I'd have to do to get held in contempt in here. And by the same token, my view of the role of the judge in that scenario is to keep people from getting to the point where they engage in behavior where they might be held in contempt. And I learned a great line from another Worcester judge years ago where the opposing counsel was railing about how offended he was by the settlement offer that had been made to his client. And the judge said to him, counsel, it's your client's job to get offended. It's not your job to get offended in the case. So I think that the role of the judge in that scenario is hopefully to maintain the decorum in the courtroom and also to lower the temperature in the courtroom through their own conduct such that.
You can always recess, right?
Yeah.
And I bring it up, there's one case in particular that I've talked about over the last year or so, which is Commonwealth versus Ulani, which was in juvenile court, but a judge held a child in contempt for a blood burst.
Right.
I mean,
That's difficult.
It's beyond.
Difficult for me to imagine a scenario.
Okay, I said it was my last question, but my last question is more of a comment. You promised me you would visit the houses of correction and other facilities where folks might be sent based on your decisions. Is that something I can count on?
You can count on it, and as I
for the years, not just now and then forget. Yeah.
Yes, and as I told you before, I've been to the departmental segregation unit at MCI Walpole, I've been Bridgewater, I've been to Women's Prison in Framingham, I've been to Shirley, I've been.
Yeah, past the minimum security, right everywhere you can access.
I sat in the segregation unit where I was completely terrified because it was me and two chairs bolted to the floor.
Yeah.
And who didn't know who I was.
Right. I feel really good about your nomination. We had a great conversation, and I plan to support you next week.
Thank you very much, Councilor.
Thank you, Councilor.
Councilor?
Who's next? I'm good, you've confused me.
Well,
change the speak. I think he loses his spot. I'm kidding.
Go ahead, Councilor Judith.
Certainly will give us.
speak anymore, you forfeited.
I got a couple of beefs, not with you personally. Grand jurors. What do you know about grand jurors?
I've read a little bit about how cases start with grand juries in the criminal setting. Beyond that, I wouldn't want to say the wrong thing, so I'm going to plead ignorance beyond the fact that I know that we have grand juries. They're often confidential, and information is presented there, and that indictments come by way of grand jury often.
What do you think of that indictments come that way from a grand jury? Do you think that's a good process?
Well, all I can tell you is that I'm familiar with I don't remember which famous lawyer said it, but someone said you could indict a ham sandwich in front of a grand jury.
Kennedy.
I actually wanted the ham sandwich. I'm on a diet, so
Well, if that's the case, and that is the case for all people who practice a lot of criminal law, you as a judge get to rule on what happens in a grand jury sometimes, right? And knowing that joke, which is probably not a joke, it's probably the truth. Knowing that, how would you look upon a motion to dismiss the indictments for want of probable cause in a grand jury?
Well, there's certainly case law that supports dismissal of an indictment at the grand jury stage, and I'm a novice, I'll admit, to criminal law, but one of the things I read about was, for example, misstatements or misinformation that's provided in a grand jury setting being grounds for dismissal. And I can tell you as a general proposition that I think that anyone who brings forth an affidavit, either whether it's for a search warrant or for in the grand jury process, that people have to be held to a high standard in terms of being truthful in that regard. And
In order to do that, though, sometimes the case is a very well-publicized case, and it's a very offensive case to a lot of people when the grand jury accuses a defendant of certain actions. And with all that publicity and with all the high stakes in the game, the Superior Court judge has to have a lot of courage.
Best I can tell you on that, Councilor Jubenville, is that advice that I have given clients of mine or physician clients of mine for years is that in order for them to do the best they can for their patients in a particular scenario, they have to be able to be dispassionate, even when it may hurt their patient to hear what they have to say, or even though what they may do may cause physical pain to their patient to do it.
I don't think it's dispassionate. I think it takes an enormous amount of guts to throw out an indictment. Everybody in the room is there because they want you to sustain that grand jury process.
I apologize for being long.
The question is a very simple one.
Yeah.
You're going to have the courage to do that.
Yes, and I apologize. It was a long-winded way I was getting there, but I promised I was going to get there. Yes.
Yeah. The other thing about, you did say you talk too much.
I do.
Okay. You know what happens when judges talk too much?
I'll learn to talk less.
You know what happens when judges talk too much?
They probably get in trouble.
They do. Yeah. They regret saying things sometimes.
That's not so much in my nature. I did.
And it doesn't have to talk too much.
No, it's a different role. And in candor, when I say I talk a lot now, it's because I love being in front of a jury educating people about stuff. But the role of the judge is different.
Well, yeah, look, to me, some of the best judges I've ever been before are judges who don't talk hardly at all.
I agree.
You get a sidebar, blah, blah, blah. In fact, I knew a judge who was a wonderful judge who I didn't think could speak for many years. Because he would tell his clerk what the results were of a motion or for a jury waive trial or that.
I can think of one of Judge Wren's former colleagues that was very much the same way. And the highest compliment that as trial lawyers we can pay to judges is to say, he or she is great, they leave you alone and let you try the case.
So, moral of the story is, he never got in trouble by anything he
Good
said.
advice then.
So when you get hot on the bench and you make some statements, that's when problems start. So I take you at your word, you're gonna have the courage to do that. And I take you at your word, you're gonna, not talk too much on the bench.
I appreciate the advice.
House, and somebody say to me, hey, do you know, this judge that's up here, did you vote for him? Say, yeah.
I appreciate that, and the best I
He
can.
says to me, terrible, he talks too much.
I don't think I've lost my temper with another lawyer in 25 years.
It's not about temper,
No, I understand.
talking.
I understand. Good.
Said the better. The other thing I want to ask you is, have you ever read the book Talking to Strangers?
The title's familiar to me. I have not read it though.
Book by Malcolm Gladwell.
Oh, yeah.
I think every judge should read that book because it tells you, it shows you how wrong we all are when we talk to strangers. You're going to be talking to a lot of strangers in the courthouse, and you're going to be looking at them. And you're going to say to yourself, oh, look at him, he's not looking at me, he's looking down, or he's nervous, so he must be lying to me. All of those things are not true in more than half the time. And that book will show you that you shouldn't, or nobody should use those expressions by anybody to mean one thing or another. You know, you heard the expression, he showed no remorse in the courtroom. Well, most of the time, lawyers tell the defendant not to show any emotion. Because there's people in the back, you start showing emotion, pretty soon you got a courtroom that are yelling back and screaming. So, but there was a judge, a Superior Court judge, who used to say to me, you know, I'm not, whatever it was he wasn't going to do because your client didn't show any remorse. And I said, I told him not to. He said, no, he didn't show remorse. Everybody has remorse in their own way. Some have none. It's just the way they were brought up. So I would suggest reading that book would give you an insight into some of the things you observe and not to form the thinking that we all have had.
It's a great suggestion. Thank you.
And the diversity study for Judge Gantz from Harvard, you read that?
Good.
Who was putting all these people in jail, these minority people? Judges?
Well, juries were convicting them of the offense, but judges were ultimately sentencing them. But
The only people I know that could put somebody in jail in this Commonwealth is a judge. So are they putting too many people in jail of the minorities?
the short answer, I think, is probably yes, in the sense that we have, we incarcerate more people than there may be one country or two countries in the world that incarcerate more people than we do, but there aren't many.
So are you going to be on the bench locking up people and putting them in jail?
It's not why I applied for the job. No, it's not why I applied for the job.
I just very quickly, you ever read the book by Judge Edward F. Hennessy? Do you know who he was?
I do.
He was the chief of the Supreme Judicial Court for 13 years and a judge for about 25.
I recall.
He wrote a book, Excellent Judges. Did you read that?
No,
Read that.
I'll get it.
He talks about us talking too much. But he also says that age is a factor. You got the right age. Anyway. Also, he says one of the best things, the most important things, is to have litigation experience. You have that civilly. So you're going to have to get up to speed. And I know they're not going to put you in a murder case your first time out. If they do, jump with Judge Brent and stay with him. He'll do it for you. He'll show you. So anyway, Judge Callan, as I told you, called me over the weekend and gave you high praise. And I know you've known him for a long time.
Thank you.
Great guy. So I likewise am going to be voting for you next week.
Thank you, Councilor.
Thank you.
Thank you very much. Save the best for last, the Dean, Councilor Ianella.
I don't have too many questions. I get it. You're right. You do some work. It's, if you don't know this answer, it's totally fine. I'll throw it on judgment.
All right?
A search warrant. And a search warrant. These come to your house.
You have an attorney present.
Can you have, family member, so you can come into the Jewel's house, my house, and my wife's there. Can she leave us up?
I may get the wrong answer. My sense is yes, if they don't interfere with things.
Well, let's assume, no, obviously, that's again. So your lawyer, and a few members who live in the house. Anyone else?
I honestly don't know the answer to that.
What if they come to my house and I have surveillance cameras? Which is probably because I'm nervous. Can they tell me to turn them off?
I know, for example, the only analogy I can make is to, in a public location, you're certainly allowed to film
I'm talking to
interaction.
I'm talking
In the house, I'm not sure they have the right to tell you to turn them off. You're wrong.
You want to take that?
I'm going to decline.
I like it.
Question?
That's good. The reason I bring it up, recently, you got two well-known, not going to mention, but we've all heard of them. One of them said you should be in court tomorrow. They can't force you to turn the surveillance cameras off. Okay, I guess that's what happened in the last couple of days. The lawyers were outside for 9 hours. They couldn't come in. So different answer than yours. Right. We got it. And I don't expect you to know. We just that. Maybe the next time you appear on behalf of someone, I'll ask you that question. I asked a couple of judges. I don't get the same answer. Which is, I like Brent's answer. Give brother. He answer. Yeah, but I don't know the answer. I do personal injury now, but I didn't see it. That never came up. But yeah, I don't know the answer.
Question we're certainly going to see more of as more and more people have, whether it's door cameras or surveillance cameras.
Yeah, I mean, my office is on Court Street. I went to lunch with my law partner last week and police were in front of the vehicle, and another member of the vehicle had his phone. I mean, is there really much difference that, getting with the phone or keeping the surveillance cameras on if they come to someone's house?
Particularly in private residence.
In private residence, yeah. But yeah, we'll ask more people that question, but yeah. Okay, so you come to a big law, 100+ attorneys. You want to go on vacation with your wife, you could say, hey, I'll get something to return. Excuse me, it ain't my case. Because this judge is a pain in the neck. He really doesn't like to allow continuances. But a lot of people, look at the people in this office, they're all sitting down. They firm. What is it that? What are you gonna know? It's the third time. One of these guys, Mary Early's, they asked for continuance. Why? I mean, let's assume they have another matter in another court. They got a new client last night and they want to get paid. You don't have to worry too much about the rent and the electric bill. You do to some degree, but people who are sole practitioners, they have to worry about the rent, paying the paralegal, the secretary. So now it's the case has gone 3 times. Request the continuance. What are you going to do?
I think it depends on the circumstances. I can tell you as a practical matter.
Well, let's go. So what are you in circumstances? I come in because I want to continue. Give me an example you'd say no to.
Someone who didn't have any explanation for why they needed the continuance. I think I'd have to hear the explanation in terms of this. Yeah. What's always been done with me in that scenario is oftentimes it'll be a matter of priority. What is the other case? How old is the other case?
Why do you care? Why do you care if the other case is a year older?
Well, I'll say it to you this way, Councilor, that I'm incredibly sensitive to people's lives, and I tell lawyers that work with me that, and I tell my own family, family comes first. If someone comes in and has a reason why they have a family obligation or something that they would need a continuance for something, I would have a very low threshold for doing that, because I've had situations where people have held my feet to the fire, because my trial schedule is such, a lot of times I can't take vacations because of how I'm stacked with trials. So I have a very low threshold for respecting people's personal obligations that would be grounds for a continuance. I think the question comes down to whether it really seems to be someone trying to duck something or dilatory versus someone having a reason why they need a continuance under the circumstances. And I get solo practitioners that.
They're backed up.
Yeah.
These guys are busy. They don't want to go in front of this shit. They're backed up.
No,
and maybe our law team is not a legitimate reason. I had a trial 2 weeks ago. They just got to catch up on the paperwork. I get the sense that if I came in front of you and said, yeah, I had a trial 2 weeks ago, and you know, it was a big trial, and I'm just backed up in paperwork. You know, I need a continuance because I haven't had. I get the sense that it's not automatic for you.
I'm not a technocrat, Brianella. I really am not. I'm sensitive to people, and I know how hard this job is and how hard this job is on people. And certainly what I would strive to do is hopefully to be treated the way that I've been treated a lot of the time, but not all of the time, which is to be sensitive to those situations and recognize that we're human and that it's a tough job. And so I didn't come to this job or apply to this job because I wanted to be a technocrat to enforce deadlines all the time either. I probably shouldn't be saying that out loud, but that's not why I wanted to do this job.
You talk about you want to treat people the way you've been treated. There's some stories there. One nominee sat in that chair, and her husband had a surprise vacation for her, 25th wedding anniversary. She said, no, I wouldn't give a continuance of that. He should have known my schedule. Maybe that could have been one of your experiences.
I wouldn't be able to say yes quickly enough in that scenario for a complaint.
When we had another one, my continuance, thank you next week, come to my courtroom. What does that mean? You're gonna charge the client, say it's a criminal, you're gonna charge the client even more money. Some judges do that. What would you do in that situation? If you make the client come up to the courtroom and argue a continuance if the case was on for trial next week?
As I said before, I'm not a technocrat in that regard. I'm not a stickler for deadlines. I understand that the courts have to work in an orderly fashion, but I can tell you that probably the single biggest complaint that I've had in recent years as a practitioner is feeling like no one cares anymore about what it's like to do this job and to practice law under the challenging circumstances that we all do. So I like to think I would be sensitive and sensible in those scenarios.
Yeah, you talked about, I did want to know how old the case was. A federal case over a state case. I assume the federal case, well, you tell me, federal case takes precedent over a state case?
It sometimes depends upon what the judge in the federal court is saying in that regard, not necessarily though. And the only reason I raised the...
What that means, you have a federal case in Texas. You got a Social Security case in Texas. And there's no continuances. If you get, I doubt you've done, I guess.
I haven't. I've had some colleagues that I've hired that have.
Social Security case, number one, folks, it takes 2 years plus to get a hearing. 2+ years to get a hearing. And if you do continue it, say the attorneys got COVID, you're waiting another 6 months. So I said that. So now the case is on for the 4th time. We don't have big firms here. So I got a federal case in Texas. Get continuance.
Oh, I can't imagine ever jamming someone up on that. You can't be in 2 places at once.
And even though it's the 4th continuance.
If
Yeah, the lawyer's asking for continuance has been the 4th time. We don't know what the other 3 were, but he legitimately has. He's the notice. I got a federal case in Texas.
the lawyer has to be somewhere else and there's one of them and they can't be 2 places at once, then you give a continuance in that circumstance.
Okay. I hope so. It's not a big problem in the court system. Not a big problem. It's a minor aggravation. You all know who the lawyers are. We don't want you to be on that list. It's a short list, but we want to make sure you're not on that list.
I'm very conscious of the problem because I've lived it. I really am.
Yeah, no further questions. I think you're going to do a great job.
Thank you.
You know, you have the experience, you got criminal. You can't be, an expert in everything. I got it. You know the personal injury field perfectly. I mean, you've done it for so many years. When your name comes up before us tomorrow, you can come.
Thank you very much, Counselor.
Thank you.
Thank you very much, Councilor Ianella. I really enjoyed not just our time on the phone, but getting to sit with you and talk a little bit more in depth about what informs you as a person, because that's, you know, like I said to you, and my colleagues are probably sick of hearing me saying it after 10 years, but you know, I know you've got a good resume. I know you can use Westlaw. I know you're smart, but many of the things you shared with me privately, but that you also shared publicly with folks here and the people at home, is what informs you to be who you are and make the decisions. And some people call it empathy or compassion, whatever, but to me, it's what makes you uniquely human. And Attorney said, and I think you're very correct, that the most important, you know, everyone goes to court and they want to win, but they want to be heard and they want to be seen and they want to be treated with respect. And I have every confidence that you will do that. As I told you privately, the day someone goes to court, it doesn't matter what it's for. It's the most important day of their life. You have sometimes their liberty in your hands, and it's important that you treat that with care. Not just law, but respect and with care. And, you know, I am cheerleader for the underdog, cheerleader for the unseen and for social justice. And in the way that you were able to interact with me and answer my concerns when I voiced them about different groups that I don't think are seen or heard very much. And we have a habit in this building and in this chamber, and all of us, just because we're people and humans, to often publicly say the right thing. But when it comes down to really doing it, it's hard. And so I actually have confidence that you will be one of these people that does the right thing. And it makes me feel confident, and it makes me feel good, and it makes me feel proud to live in this Commonwealth and that you applied for the job. So you have my every confidence. And with that said, hearing adjourned. My name is Eileen Duff. I am the counselor presiding today, and I will read the letter of nomination, and then we will start the hearing. I am pleased to nominate Brian J. Costa to the position of Clerk-Magistrate of the Salem District Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm enclosing the nominee's resume for your convenience. Sincerely, Charles D. Baker, Governor. With that, we will call your witnesses and seated.
Coach.
Coach, can you tell us your name and give us?
Marvin Avery, I'm a court officer in Salem District Court. I also coach basketball in the city of Lynn. They call me coach because I coach basketball year round. I coach some of the inmates within and out the Salem Marine Center.
Excellent, thank you. And what do you want to tell us about this fellow?
First of all, I met Brian about 10 years ago when he first started coming to Salem, working with us. We bonded from day one, talked about sports. And he asked me what the job entitles about, being a court officer. Just, I told him it's like friendly Fenway. You treat everyone the same, very lot of diversity, whether we're doing Zoom or we're in person. Brian was always there. If I had to stay late in lockup, get a mid done, he was always there to help out. And not only just me, but throughout the whole Salem Marine Center, whether Superior, District, Juvenile, or Land and Housing Court. He was just always there for the people. And the bottom line, that's what it's all about.
Thank you very much.
You're welcome.
Any questions?
No question, thank you.
No, thank you, Coach, for your testimony. We have Judge Randy Chapman, who's the first justice in the Salem District Court.
And by the way, I was on Zoom there this morning. Judge Costa is doing a great job replacing you.
Good afternoon.
How are you?
As indicated, my name is Randy Chapman. I'm now the first justice of Salem District Court, and I want to wholeheartedly endorse Brian as a clerk magistrate. And I don't say that obviously lightly. We're going to be presumably married, if you will, for many years to come. And so I would, I certainly, with respect to any recommendation that I would give, it would have to be somebody that I would feel would be qualified. Brian is qualified by way of skill, temperament, and knowledge. On a day-to-day basis, Brian can cover any session in the court. He can be a session clerk. He can handle civil motor vehicle infractions, search warrants. He can handle bail hearings and bail issues. He can cover everything in any session, and he's trained his staff that he inherited from Judge Lawler and from our esteemed colleague that's here today, now retired, Dave Sweeney. But he is capable of doing anything, and all his staff is capable of doing anything, which allows us the flexibility in court to manage it in the midst of a crisis when we have to go to a skeleton because it's either because of COVID or because of a snowstorm. Anybody can come in and handle any particular session. And certainly that's not to say that certain people don't have strengths, but Brian, through his leadership, I think has established that we have the capability of responding. We were buried in a backlog, as were many courts, and we've dug out of it so quickly because of Brian's leadership and his staff, incorporating the technology of Zoom that saves lawyers tremendous amount of time coming to court for pretrial hearings. Lawyers that are in remote areas don't have to come to our court. Brian has got that going in every session, and that has allowed us to dig out. So now if somebody comes to our court and wants a speedy trial, we're able to do it. You can have a trial in our court within a couple of weeks if necessary, if that's what you want. So that's largely, again, because you have a staff of him. By way of temperament, he never loses his temper. I've seen him work with the staff, with the public. They are the first people that obviously the public comes in contact with is the clerk's office oftentimes. There are many clerk's offices that I dealt with when I was in private practice, and I've been doing this now for 36 years, both on the bench and as a lawyer, that you would go to. And if you just ask for a docket, they would say, make an appointment, order it, you can come back in a week and get it, and you need it for the next day for a trial. Brian's staff responds immediately. You walk into that court office, that office, or the clerk's office, they will come, they'll talk to you, they're not going to ignore you while you're sitting at the desk, they're going to get you whatever it is that you need to the extent they can. And he's just simply calm and cool, and he sets the tone. He works collaboratively with all the other departments. Many courts that I've sat in are dysfunctional in a lot of ways because the clerks don't talk to the probation doesn't talk to the court officers, and it's a problem. We can't get the business done of the court. Brian's staff and Brian work collaboratively with everybody. They get along with everybody in the staff, and I hope that you confirm him, because I hope to see that continue. Let me just end by one anecdote that I think reflects Brian and his staff. A short while ago, I had an individual who I had revoked on his bail. It was a 21-year-old young man who lived in Boston, came to Salem. He picked up a firearm case. He was out on bail on the firearm case, and he violated it with a series of larcenies. It seemed like every time he came to Salem, he would find himself in trouble. And I revoked his bail at the request of the Commonwealth. And after a short period of time, I had suggested to his lawyer that if they could come up with conditions of release that would make sense, that would keep him on the straight and narrow, I would be willing to consider it. And they filed an extensive motion with suggestions of a GPS where his mother would be in the custody of his mother, programming, employment. And I had gotten the motion on the Thursday before Memorial Day weekend. I decided to allow it. Brian and his staff had that 21-year-old person before me the next day. They had arranged through probation to make sure that a GPS was there, to get the defendant caved in. And sometimes we lose track of the fact that this young man was now going to spend until at least next Tuesday. In some courts, it would be several weeks before he would be brought before the court. Because they take every individual's liberty seriously, they take it with and are willing to respond. They were able to get the sheriff, to get the defendant there, to get the hearing marked up for a hearing, and he was released as a result on the Friday afternoon. So I think that just simply reflects the kind of individual that Brian is, and why I think he is so perfectly suited to be the Clerk-Magistrate of Salem District Court, and I ask that you confirm him.
Thank you very much, Judge. Questions from the councilors? Councilor Jubenville.
How are you?
Okay, Mr. Jubenville.
Good. My pet peeve of the month is I have been told that in certain court, in New Bedford Court, that if your case is on for trial, you show up that day. The DA come to an agreement. Can't plead.
You can't plead? Not sure. I don't know why that would, that sounds to be, I understand sometimes there's issues regarding going jury waived on the day of trial, that there's some issues regarding that sometimes, but I can't understand why a person can't plead guilty. That would be, it doesn't make any sense.
Never heard of
It doesn't make any sense to you either.
I don't know whether it's a law, but it's certainly rules or been done. It's always been my impression a defendant can flee all the way up and the jury comes in if it's a jury trial.
Sure. I mean, I guess it's a question of disposition and but I don't know how you can prevent somebody from pleading guilty. That makes no sense. That's not in Salem. We resolve most of our cases, frankly. A lot of the cases that are scheduled for trial are resolved on the day of trial. Because you don't know sometimes whether someone's going to exercise a privilege or go forward or who's going to show up. So, and we certainly don't punish anybody for exercising their right to a trial.
I think so. The other thing is you mentioned that going jury waived. And there is a case that came down, I think, a year and a half ago, in Western Mass, who defendant showed up for trial. He said, my client's exercising his right for a jury waiver trial. I know the judge, and nobody in their right mind would ever jury waive the trial. But anyway, this lawyer did.
The judge rejected the waiver.
He said, you have to give me a compelling reason. And he said, I don't have to give you any reason. It's his right to do that, and he wants to exercise it. He wouldn't let him do it. But the SJC said, defendant has an absolute right to jury waive it without giving any reason why, up until two caveats, I think. Number one, if it's a co-defendant case, they all have to do it. Or if the jury has been picked, then you can't. You started the process of picking a jury, then you can't waive it or something.
I'm not sure that's my reading of the case, because I actually watched the arguments on it, and it was of interest because originally I was on a committee that dealt with jury waiver following the OUI scandal issue.
What was the take you had on that?
It wasn't the case, this case that you're talking about, that I remember that came down recently. Debo, and it said you have a statutory right to waive the jury on the day of the election. On the day of trial, there has to be some cause, or at least if the judge asks for it. I don't typically ask for it. But they upheld the decision of this committee, the rule that was established, that there has to be some showing, if asked for, and the Commonwealth would have a right to object to it. The idea of trying to limit jury forum shopping. So I think you have a right on the day of, on the election day to go jury waive, because you don't know who you're going to pick. So I don't know who necessarily waives their jury on that event, but some do. And on the day of trial, typically, I just can tell you that in our court, I don't think I've ever did a jury waiver. If you think that somebody's doing something improper, I think you would have a right as the judge to reject it.
Yeah, that right if anything is being improper, but I have to read that decision again, but I didn't think a judge had to give any reason for it, just that you decided to go that. But a lot of times, as you well know, that when at the pre-trial, when you pick, say I want my jury, I want a trial, the judge will say to me, jury or judge, and I say, I can't make that decision. In fact, to make it would be ineffective assistance.
Well, that's the argument of why you wouldn't want to typically pick one on the election day either, because you don't know who you're going to get. But
well, that's why you save it for the day. As the SHC justice said, you should know before you waive what judge you're getting.
I agree. Look, I think, as I've said many times, I think the defendant's right to, it's defense counsel's obligation to try to forum shop to the extent that they can. That doesn't mean the court has to capitulate to it, but I think the defense counsel has a right to know who it is they're trying it before.
I don't get the forum shop though, because if I pick a trial date in your court, I'm picking one at least a month, if not further, right?
Right.
I have no idea who's going to be there that day. I have no idea when I get there that day, even if I looked at the schedule, whether that judge is going to be in that session, or whether he's even going to, maybe took a day off for some reason. So.
And you wouldn't waive.
So, depending on who it was. Foreign shopping to me is, I'm scheduled to go to jury room A, and I know there's somebody in there who I wouldn't want a jury waive with. So I tell the clerk, can you take my case and move it to jury room B? That to me would be judge shopping. I can't do that because I don't know who's sitting when I come back that day for trial.
You know,
I don't know who's sitting. I make the determination that day. Because we keep a book on all you guys. Luckily, you're in good shape in the book.
Thank you.
Thank you very much. Good to see you.
Thank you. Are there any more folks here to testify on behalf? Is there anyone here to testify against? Hearing none, before you make your statement to us, Mr. Costa, is there anyone here you'd like to introduce to us?
I'd like to introduce and thank all the people who are present here today to support this nomination. I have here today with me my wife Jenna, our children Mackenzie and Cameron, my parents Frank and Mary Ellen Costa, my mother-in-law Dottie Vanna, my father-in-law Peter Vanna and his wife Pam and her daughter Abby Abdenor, my dear friend and recently retired First Assistant Clerk-Magistrate David Sweeney, my witnesses First Justice of the Salem District Court Randy Chapman and Court Officer Marvin Avery. I would not be sitting here today before this council without the continued support of these individuals and many more individuals who have helped me over my career. I would also like to thank Governor Baker, Lieutenant Governor Polito, Chief Legal Counsel Bob Ross, Executive Director Lauren Green and her staff, the Judicial Nominating Commission members, the Massachusetts Joint Bar Committee members, former Chief Justice of the District Court Paul Dawley, former First Justice of the Salem District Court and recently appointed Associate Justice for the Appeals Court Robert Brennan, the Salem District Court employees, host counselor Eileen Deff, all the members of the Governor's Council. I thank each and every one of you for the guidance and support you've provided me over the last few months. Your assistance and encouragement will be forever cherished by myself and never be forgotten. I am aware what this potential opportunity presents. As a way of background, I tell you I grew up in Woburn, Massachusetts. I'm the second oldest of children of 4. I attended Woburn Public Schools through 8th grade. I spent my high school freshman and sophomore years at Boston College High School. I can remember my father dropped me off in front of City Hall around 5:30, 6 o'clock in the morning to catch the MBTA bus. Only then to be dropped off at Park Street Station to catch the Red Line to the JFK station, then walk down Morrissey Boulevard to Boston College High School. During hockey season, I often found myself commuting back home late in the evening. To say the least, not an easy task for a high school freshman. I attended the Pingree School in South Hamilton for my junior and senior years. There I played hockey, baseball, and ran cross country. From approximately 6th grade through high school, I delivered the Woburn Daily Times and refereed hockey. In high school and in college, I worked for an irrigation company and landscaping company. I also had several lawns of my own I would mow for some extra money. In winter months, I would plow snow. Putting it mildly, I was not a person to sit around. My experiences at Boston College High School and the Pingree School, I knew when it was time to go to college. A smaller sized college is what best suited me. I attended Assumption College in Worcester, Massachusetts from September 95 through May of 1999, receiving a degree in business management. In March of 2001, I was fortunate to begin my career with the Massachusetts Trial Court as an internal auditor. There I visited all the various departments of the trial court. I sit here before you today with a unique background as it relates to the trial court. I tend to think of the 12 years traveling the state as an internal auditor. I became familiar with the behind-the-scenes operations of the court. I conducted many audits reviewing payroll, procurement, funds management, and case management areas of a particular court. Over the years, I spent time in our civil session. I'm sorry. No, you were absolutely right, Councilor. I also completed special projects like training court personnel in certain areas of their job functions and conducted many theft investigations within the trial court. In fact, I played a significant role in uncovering a $2.1 million theft in one of the state's probation departments. I also played a major role in preparing courts for the transition to mass courts, which ultimately increased the funds management responsibilities within the Clerk-Magistrate's offices across the state. In March of 2013, I was again very fortunate when I was hired as an assistant clerk magistrate at the Salem District Court. On my first day, a wise first assistant clerk magistrate there, Mr. Sweeney, told me if I can run Session A, I can run any other session in the building. For those who do not know, Session A is the main session of Salem District Court. Mr. Sweeney always referred to it as the emergency room of Salem District Court. I took Mr. Sweeney's advice and I learned to run Session A with ease. I went from behind the scenes operations now to the front lines of the court system. I've also spent an abundant amount of time in our motion and jury sessions. Over the years, I've spent time in our civil sessions and have presided over countless show cause and civil motor vehicle hearings. Somehow, some way, I have no clue how this happened, but I became the go-to guy when there were issues. Whether it was an IT issue or issues like we have a custody at the hospital or the jail has issues with the paperwork they received and the court is closed, I seem to be the guy handling these matters. Then COVID hit and the number of issues compounded tenfold. To tell you the truth, I enjoy being the go-to guy in the building. With that said, I tend to think of the clerk magistrate as the leader of the employees who work in the clerk magistrate's office. And let me tell you, Salem District Court is probably one of the best teams in the Commonwealth. I enjoy being part of the community and helping the citizens of Salem's jurisdiction be a better place to work and live. In closing, I ask you members of the Governor's Council, please put your confidence in me like countless other people have over my 21-year career with the trial court. I ask you for your consent to become the next clerk magistrate of Salem District Court.
Thank you very much, Councilor. Do you want to go first, Councilor Kennedy?
Rule is that you go to the person who sits next to you.
On the right.
Oh, I am unaware of that after 10 years, but I will go to you, sir. Councilor Kennedy.
Thank you. I'm going to talk about Dave Sweeney first, if you don't mind.
Don't mind.
Like it or not.
40 years in the Salem court. I've been doing this 39 years, and I remember him when I was a very, very young lawyer going into the Salem court, and how helpful he always was in the old Salem building, coming out with Judge Doyle all the time, and calling the list, and really did run an efficient session. And he's the big loss that you're going to have when you become the clerk magistrate. And he's to be congratulated for his many years of service and the way he treated not just the members of the bar, but every defendant that came in there was the way, it was the model how a court should act.
Thank you very much.
Now, I don't have any questions for you. I've obviously known you for a long time. We have a great relationship. I bother you all the time every time I need something up there, and you've always been accommodating, as not just with me, with everybody that comes in there. I just want to point out that the day that the Clerk-Magistrate retired, all I heard from your council was, "That's Costa's job. That's Costa's job," over and over and over. She's a big fan, and has been. I know she's been pushing very hard for your appointment, and you should be very thankful for that. And obviously, I'm going to be voting for you next week.
Thank you, Councilor. I am thankful.
Thank you. I'm so confused now. Can I go back?
Keep going, you go right around.
How did I not know this? I don't get to chair enough meetings. I want that to be on the record, that not enough people from my district.
That's it with the 15-minute rule.
Okay, Councilor DiPaolo, I'm really just pulling your leg, I don't care.
Council. You can just always remember that Councilor Kennedy is far to the right of you.
Everybody's part of the
I was gonna say everyone's part of the right of me.
Thank you, Councilor. Good afternoon.
No, sir.
A few nights before we finally had the chance to talk, I was watching TV. I was watching Peaky Blinders on Netflix. And I was thinking of you because I was thinking about nominations. And so I received a phone call while I was watching that iterated a point that's kind of my first question about a clerk. And it came up today from your witnesses. And that is, if I showed up at Salem Courthouse, what would people say about you and why?
I would tend to think they would say I was a hard worker, a great work ethic, good customer service skills. If I'm helping someone at the counter, I believe Judge Chapman had said, some courts would say, come back in a week, go to the file room and go get that document that you need. You're not leaving without anything that you came to court with.
Yeah. And as we all know, the clerk's office is the first point of contact for the
centerpiece of the
public when they're rolling through. And so that initial interaction is so important. So it's important to me that we have clerks who want to help, who are there wanting to help people.
We're there to serve the public.
And, we've heard examples. Are there any, do you want to share any other particular instance where you feel like the job is giving you a chance to help someone?
Sure, absolutely. So in the show cause hearings, Clerk-Magistrate has authority not to issue a criminal complaint.
Right.
Even though there's probable cause, unless the district attorney or the attorney general communicates to the court that they want to prosecute the case. So that gives the Clerk-Magistrate a lot of authority in those show cause hearings. And if an individual, whether it's a college student, anybody that comes in that hearings room, and if they don't have a record, I'm going to work my hardest to preserve that record. If there's anything that, I can work out with the police prosecutor. And again, if they don't, if they object, I can still try to work something out with the defendant in order to preserve their record.
Right, and I appreciate that, because unless public safety is concerned, I think it's better to divert people.
Right, again, it all depends on the severity of the case, the charge itself, if there's a victim in the case, and so forth.
And one thing we discussed, which I don't bring up because I think you disagree, in fact, you said you agreed with me, but when we think about folks coming before you, just as a simple example, as like a Salem State student who doesn't have a record, there's also kids who are from backgrounds where they never had opportunity for college. They might be, involved in the same behavior, and I would hope that folks are giving them the same break. And because you went to college in Worcester, the example I often give, I don't want to besmirch Assumption. So I don't know if kids smoke pot at Assumption or not, but I know they do in other colleges in Worcester, and I know they do in Maine South too, And so, but I also know that kids in those two scenarios end up on very different paths sometimes.
Sure.
And it's not necessarily because their behavior or their judgment was any more egregious than the other. It's strictly to do with context.
It doesn't matter who the individual is.
So the conversations I've had, the conversation I had with you, I feel really good that you're going to be someone whose priority is to help people and to be good to people and make people have a good experience in the courthouse. So I have no further questions. I look forward to supporting you when we have our vote next week.
Thank you, Council.
Thank you very much, Councilor Powell. Councilor Jubenville.
Yes, so, where did you grow up?
Move Massachusetts.
And how come you went to Boston College High School?
My parents gave me the opportunity. I wanted to be different, and so I ended up in Boston College High. I knew a number of gentlemen that were going to St. John's, Matanon, AC. Didn't know anybody going to BCI, so that's how I ended up there.
You didn't want to go anywhere your friends were.
Correct.
That's why you're sitting in your seat right now. I think you have a great resume for moving up to the position.
Thank you, Councilor.
Your home counselor's been very vocal in his support from you, and Councilor Kennedy knows you a lot better. So with those two recommendations in your background, I think it's a no-brainer for you. So I'll be voting for you next week.
Thank you, sir.
Thank you, Councilor. You know, honestly, Mr. Costa, you've earned this job. I have had interactions with you in the court. I've brought you people that needed help, that I could no longer help. And you were not just professional, you were patient and you were kind. And those are attributes that we don't always get, that I don't always give. So I greatly appreciate you and your service to the Commonwealth. And I thank you for applying for this, because I believe this job should be yours and that you have absolutely earned it. And it would be my absolute honor to put your name into nomination when we next meet for a vote. With that said, this hearing is adjourned.
Awesome.